Hello, thank you for joining us this morning and welcome to our data protection webinar. My name's Cathrine Ripley. I'm a partner at Field Seymour Park Solicitors in Reading. I lead our commercial and technology team, which advises on a wide range of commercial contracts, intellectual property issues and data protection issues. Before we get started today, just a few housekeeping points to run through first. Everyone apart from the speakers is on mute, but we'd really like your comments and questions, so please pop them in the question box on screen. The webinar will take about an hour, and within that we'll have a Q&A session after the main presentation. During the presentation, we'll be conducting a few polls, so please do get involved in these, not least because it's nice for us to know that there are a few people out there listening to us. The slides that you'll see can be downloaded from the handout section on screen, and a recording of the webinar will be sent out to all attendees later today. Feel free to share it with any colleagues who you think might find it of interest. We'd really appreciate your feedback, so please complete the short survey that will appear on screen at the end of the session. All completed surveys will be put into a prize draw for a £50 John Lewis voucher, so please do take part. I think that's everything on the housekeeping. So today's session is going to be presented by me and my colleague Charlotte Burroughs, who's a solicitor in our commercial and technology team. As you probably are aware, data protection compliance is a risk management issue. How you actually comply with the law really depends on what your organisation does and how you assess the data protection risks associated with your operations. Once you've kind of assessed the risks that you have, it's important that you take actions which are proportionate to those risks. Accountability is an important second strand to this. It's not only important that you comply with the rules, but you've also got to be able to demonstrate that compliance. Most of the organisations obviously undertook a lot of preparation in the run-up to GDPR in 2018, but question, what have you been doing since then? Let's bring up our first poll before we get started to see how you think you're doing at present. So, thinking about your organisation's current privacy compliance, how would you rate yourselves? Either we regularly review our compliance and have no major concerns, or we did a lot in 2018, but we may have let things slip since then, or there are areas of our compliance that we need to work on. So just give that poll a few moments. Have the results come up yet, Charlotte?
Yep, they're here.
Oh, right, okay. So there's a bit of a spread, but it looks like pretty much everyone thinks that there are things that they could do better, or there are areas that they could work on, and that's not uncommon. I think pretty much all of us fall into that category. Now, so if there is room for improvement, then I would suggest that a periodic review is a good way of identifying things that you could improve and taking appropriate action. You might already do an annual review, maybe as part of some other annual review process, for example, to maintain quality accreditations. But if not, I'd say it really is worth doing an annual review. And so what we're going to look at today is our top 10 list of things that we suggest you check as part of that review. And this is based very much on the topics which we see coming up time and again with our clients. Just before I hand over to Charlotte, I should perhaps just make one little point about legislation. Obviously, when the GDPR came into force in 2018, the UK was part of the European Union, and we've obviously left the EU since that. But at the end of the Brexit transition period in January 2020, the EU GDPR was incorporated into UK law as retained law. It's now referred to as the UK GDPR, but to sort of a large extent, both the UK and EU positions remain very much the same. And I think for today's purposes, we'll probably just refer to the GDPR, meaning really the UK GDPR, just for brevity. So without further ado, I'll now hand you over to Charlotte to kick off the top 10. Charlotte.
Thank you, Catherine. So the first one on our list today, and these are in no particular order, but this is something that we often see clients perhaps aren't even aware of, is the need to register with the ICO and pay the data protection fee, and a general comment around allocating responsibility within your organisation. So under the data protection legislation, there's a requirement for every organisation that processes personal data as a data controller to pay a fee to the Information Commissioner's Office. That's the UK body that's responsible for data protection, and failure to do so will result in a fixed penalty. Now, you must register if you are a data controller, and that means that you determine the purposes for which you process data. Our view is that most organisations will handle some personal data in one form or another as a data controller, and therefore it is imperative that you ensure that you are registered at the ICO. This is particularly the case given that the fines are quite large, but the fee is in general quite small. So for most of you attending today, I would presume your organisation fits within Tier 1 or Tier 2. Tier 1 being a maximum turnover of £632,000 or no more than 10 members of staff, for which the fee is only £40 a year. And moving up to Tier 2, a maximum turnover of 36 million for your financial year or no more than 250 members of staff, for which the tier is only £60 annually. So you can see there that there is really there isn't really worth taking the risk of not registering. This is particularly the case because the ICO has been contacting all or very many of the companies registered on Companies House and sending them letters asking them, reminding them to register. So you may have already received these in the post. As I said, for the majority of companies, it's not a high fee. It is a legal requirement, and the fines are really not worth thinking about compared to the fee that you would need to pay. Moving on then to generally allocation of responsibility, I just wanted to emphasise that GDPR compliance as a whole should be considered as a board level issue. It shouldn't be something that's just done at the bottom level organisation, but it should really be something that is driven from the board level. This is particularly the case given the huge increase in potential fines, and not even to think about the reputational damage that might happen in the event of a data breach. As Catherine kind of touched on, GDPR introduced a concept of accountability. So it's not just that you have to comply, but you must be seen to comply. And particularly in the event of a breach, the ICO will look more favourably on organisations that can demonstrate that they have tried to comply, and that GDPR compliance is taken seriously from board level downwards, including making sure that you have the proper policies and procedures in place. So time for another poll. I just wanted to bring this in, just have a think about what the fine might be for GDPR non-compliance, to sort of emphasise the importance of board level consideration. What is the maximum fine for GDPR non-compliance? Is it 17.5 million or 4% of annual worldwide turnover, the greater of 8.7 million or 2% of worldwide turnover, or is it a flat rate of 5 million? Just give you some time to think about this one. Okay, let's share the results. So it's good to see the majority of you have gone for the A or B. The correct answer is A. It is the highest amount listed there. So you can see that it could be for an organisation, it could be a large fine in the event of non-compliance. So again, just emphasising the need to consider this as part of your general, board level compliance. And finally, on this one, I just want to talk about data protection officers. You may or may not already have a data protection officer, and the GDPR does introduce a duty for certain organisations to appoint a data protection officer. This is the case if you're a public body or you carry out certain processing activities. But this being said, you can choose to have a data protection officer, whether or not you need to legally have one or not. Data protection officers assist in monitoring internal compliance. They can inform and advise you on your data protection obligations and provide advice in relation to things such as data protection impact assessments. Importantly, they also act as a contact point, so that if your data subjects need to speak to you about your data protection compliance or otherwise, you have that point of contact and you can make sure that they liaise with the data subjects. It's important that DPO is independent, has expertise in data protection, and is adequately resourced and can report to the highest board level, as I've touched on. And this can be an existing employee or it can be externally appointed. And indeed, there are companies and services out there now that offer the role of a sort of external DPO. Again, just want to emphasize the need for changes and reviews. This shouldn't be or looked at as an isolated process. There must be an ongoing monitoring of what data you process, because it may change, and what you did 3 or 4 years ago may not be the case now. And as Catherine again touched on, it's quite simple to sort of add this into your annual reviews that you may already undertake as an organisation.
Thank you, Charlotte. So moving on to number 2 in our top 10, knowing what personal data you hold, including special category data. It might sound like a statement of the obvious, but you can't comply with the rules unless you've got a good grasp of what personal data your organisation actually holds. And this may change over time. And importantly, do you actually take account of every type of personal data that you've got? Personal data, information relating to an identified or identifiable individual, is a very wide definition, and it's easy that things around the edges can get forgotten about. But just because they may seem a bit marginal doesn't mean that you shouldn't check that your policies and procedures apply to them as well. For example, information like IP addresses and cookie identifiers is something which sometimes gets forgotten about. Also, don't fall into the trap of thinking that you don't need to worry about personal data rules because data is anonymous. You need to be confident that it really is anonymous. We had a case a few years ago where we were acting for a reseller of Google services, and information about data subjects was aggregated and supplied to Google. It was impossible from this information alone to identify individuals, and so my client and their customer were sort of proceeding on the basis that this data was anonymised and not within the scope of data protection rules. However, it later transpired that in fact there was a second set of information or keys, and it turned out that if these keys were used in conjunction with the anonymous data, the supposedly anonymous data wasn't so anonymous after all, and actually it did fall within the scope of data protection rules. So again, it's just sort of something to watch out for, and make sure that when you're thinking about personal data, you are actually thinking about everything. Special category data also needs to be thought about carefully, because it gets special treatment under the GDPR, because it's sensitive and sort of information which data subjects would be most likely very keen to have protected. Stricter rules apply. You need additional grounds for processing special category data, and these need to be documented in what's called an appropriate policy document. Special category data often is a key risk area for many organisations, so it's really important to be aware of exactly what special category data you have, why, and take extra precautions. Again, from an accountability perspective, if you are able to demonstrate that you've taken a different, more protective approach in relation to special category data, that's likely to hold you in good stead. As part of your original implementation of GDPR back in 2018, it's likely that you'll have undertaken a data audit. Should it be repeated when you do a privacy review? Not necessarily, but there may be sort of exceptions to that. For example, if you've acquired a new business, you might want to do a mini audit of the data that's come over as part of that acquisition. Alternatively, if you are now offering new services or undertaking activities that you weren't doing in 2018, that might be a ground for investigating further, possibly by doing a data protection impact assessment, or DPIA, which I'll talk about later. But whether or not you need to repeat the audit process as part of any review, you must make sure that you maintain written records of your processing. These need to cover what personal data you process, why you're processing it, who you're sharing with, and how long you keep it. And those records need to be kept up to date, obviously. These type of records are usually electronic, and the ICO website has templates that you can use for this purpose. Now, while it might sound like a bit of a paper shuffling exercise, creating and regularly reviewing and updating your data processing records really isn't, and there are good reasons why you should keep the records, apart from the fact that the law requires you to do so. Firstly, if there is a problem and the ICO looks into your compliance, they might specifically ask to see your records. And secondly, and more practically, the discipline of creating and maintaining proper records is likely to help you think about compliance and trigger useful activity, which ought to improve your data governance. Thanks, Charlotte.
So moving on to look at, Catherine's touched on what data you process, and I now want to cover knowing why you hold that personal data. It's really quite important to know why you hold the personal data that you hold, because it will underpin so much else. If you don't understand why you hold personal data, then there's a greater risk that you hold data that you shouldn't be holding, or that you don't have a ground to hold, and there's greater risk of making confused and inappropriate decisions. You'll see on the slides I've set up all of the sort of what known as lawful basis for processing personal data, and I'm going to run through them, focusing on what I consider to be the four main ones that you're likely to be using. It's important to say at this stage that it's likely that you'll be using more than one of these, and that you'll have different grounds for different types of personal data that you process. The first is to perform a contract, and this is likely to be quite important in your organisation, and you'll be able to rely on this where you need to deliver a contractual service to them, or because they've asked you to do something before entering into a contract, such as provide a quote. So it's likely that there will be types of personal data when it comes to you delivering your goods and services, and that you'll be able to rely on this ground. The second is to perform a contract. The second is with a data subject's consent. This was often used quite a lot, particularly pre-GDPR. It seemed to be the one that organisations relied on a lot. But it is really important to say that the UK GDPR does set a really high standard for consent. It used to be the case that you could rely on implied consent, but now consent has quite a high bar. It must be explicit, freely given, and specific. And you must consider the fact that so if you're processing data using consent, consent can be withdrawn, and you still need to continue to process it should a subject withdraw their consent. You might need to think about what other lawful basis to use instead. That being said, consent is really important if you're processing special category data, which Catherine touched on, and also when you're looking at providing marketing information to your customers. The third is legitimate interests. This is probably the most flexible basis for processing, and so it's likely the one that you will use in some way or another. It's likely to be most appropriate where you use people's data in a way that they would reasonably expect, and that will have a minimum impact on their privacy. The important thing to do if you're relying on legitimate interest is to apply a three-part test. this is as follows. You'll need to identify the legitimate interest that you need, show that this processing is necessary to achieve that legitimate interest, and thirdly, to balance it against those individuals' rights, interests, and freedoms. And fourthly, the other one you can rely on is to comply with a legal obligation. This is likely to be relevant if you need to comply with some kind of common law or statutory obligation. And an obvious example being something like HMRC compliance. The remaining ones on the slides are likely to be less relevant, but I will just touch on them quickly. These are to protect data subjects' vital interests, and in simple terms, this would be something if you needed to protect someone's life. And finally, to perform a task in the public interest, such as diversity monitoring. As I've touched on before, it's likely that you'll be using a few of these, and you'll be using certain types of personal data under certain lawful basis and some under others. And you will need to undertake a task to work out what you process and why you process it for each type of personal data that you use.
Thanks, Charlotte. So number 4 in our top 10 is minimising data usage and retention. So once you have a clear understanding of what data you hold and why, you then need to move on to check that you're minimizing your data usage. Now, this is a new concept, data minimization, and something of a departure from previous thinking. Previously, many organizations almost thought it was a virtue to hold lots of data and avoid deleting it just to be on the safe side. But Article 5 of the GDPR requires personal data to be adequate, relevant, and importantly, limited to what is necessary. So as a result of this requirement for data minimization, many organizations undertook a brutal culling of data before GDPR. But obviously that was almost 4 years ago, and question whether your retention and destruction policies have been applied rigorously since then, or have bad habits crept in. Non-compliance with the minimisation principle is bad news, not only in its own right, but because it increases risk across the board. For example, if you're holding on to more data than you need and you unfortunately suffer a data breach, it's possible that the effects will be worse than they would otherwise have been. Similarly, if you're holding on to lots of data and you receive a subject access request from an individual, it's likely that there's going to be more information that you need to retrieve, more information that you're going to have to check for redaction before it's handed over. How successfully you've stayed on top of keeping data to a minimum may depend on what you did when you were preparing for GDPR. For example, if you were able to make changes to your systems to reduce the amount of unnecessary data you collect, then that should have put you in a good position. Similarly, if you centralized storage to reduce duplications, then that should also have helped. Also, if you have implemented automated processes for deleting data from your centralized systems in accordance with whatever retention policies you decided upon in 2018, that should again help. However, standards may have slipped, bad habits may have crept in, particularly I think where data deletion processes aren't fully automated and require an element of manual procedure. Another thing to think about in terms of whether you're still abiding by data minimization principles is whether you had to make compromise decisions when you were implementing GDPR in 2018. One example that we saw a lot was in relation to deletion of emails. So many of our clients would, when they were thinking about how to comply with GDPR, would make decisions about retaining emails for maybe 12 months or 3 years, but then they would discover that actually their IT systems meant that the emails were held in an archive for a much longer period of time, and there wasn't really anything that they could do about it. So often very pragmatic decisions had to be made, for example, limiting the number of users who could access the email archive so that it was much more locked down than previously, allowing only maybe the people in your IT team to access the emails in archive under restricted conditions. But while that might have seemed like an acceptable compromise in 2018, question whether that can still be justified now. It might be that your email provider has developed new tools making it easier to delete emails in accordance with your desired destruction policy. But actually, are you aware that new tools have come in, and are you using them? So, quite a lot to think about in terms of making sure that you're really keeping the data that you hold to a minimum. Coming on to number 5 in our top 10, internal procedures and staff training. The law refers to technical and organizational measures, reflecting the fact that compliance depends on a combination of both technology and human behaviours. You need to have systems and rules in place for complying with the law appropriate to your operations, and you need to train your staff to follow your rules and systems. And as I've touched on earlier, accountability is a really important thing, and being able to demonstrate that you've got policies and procedures in place and that your staff are properly trained was important in 2018 and remains important today, and is something that you need to keep on top of. That accountability element can be an important element when it comes to mitigation. For example, were you to have a data breach, which needs to be reported to the ICO, then the ICO's report form includes 2 important sections about what preventative measures you've had in place and what training your staff have received. If you're able to input into those sections some up-to-date information about recent things that you've done in terms of making changes to keep your policies and procedures up to date, to show that staff have been recently trained or had refresher training, then that is likely to be looked on favourably by the ICO when assessing the report of your breach. So the internal rules and procedures that you adopt in your organisation, they do need to be properly and clearly documented in some sort of internal document, whether that's called a data protection policy, a data protection standard, or a staff handbook. That there does need to be some place where all your rules and procedures are documented, and which can be easily accessed by staff. It needs to be a sort of living document, not just something with a lot of legalese in it, and it needs to be in language which is easy for staff to reference. We're sometimes asked what sort of form and content this internal document needs to take. As with many things when it comes to data protection compliance, there are no hard and fast rules. It really depends on what your organisation does, both generally and in particular in relation to the processing of personal data. And it probably needs to have some sort of reflection of the culture of your organisation and the other sorts of policies that you have. But whatever sort of form you decide you want to take, I think there's probably sort of half a dozen or so key areas that I'd suggest need to be covered off in your internal document. So you need to have something about the management structure in your organisation when it comes to data protection compliance, and importantly, who members of staff should contact if they've got any queries or concerns. I would also have a very sort of high-level introduction to data protection law and how it applies to your organisation, so that staff have a bit of context and a sort of very simple sort of summary of the laws that are really relevant to your organisation, and how you expect them to follow those laws. It's probably quite a good idea also to have some practical examples. really sort of drilling down into how your business operates and the sort of practical steps that you expect staff to sort of take in their sort of day-to-day lives when they're carrying out their roles, and how data protection sort of links into that. Data protection should be something that is at the forefront of your people's minds, not something that they only think about when a problem arises. Obviously, keeping data secure is a really key element of where your staff have a part to play. So providing them with information about what they need to do in practical terms would be really important, and that might then link into your more general IT security policy. I'd also include in the internal document some basic sort of procedures about what needs to happen where there's a data breach, where there's a subject access request, or where a data subject requests to exercise their other rights. The internal document that's going to be viewed by all staff doesn't necessarily need to talk about these in a lot of detail. That will be something which those with particular responsibility for data protection matters will sort of have more information about. But there does need to be some basic information in your internal document so that staff need to first of all understand the importance of recognising where, for example, subject access request is received, or the importance of reporting data breaches quickly, and so they have a sort of clear understanding of the importance of these things and who they need to escalate them to so that they can be appropriately handled. Similarly, data protection complaints should be covered, and again, staff should have an understanding of how they should be escalated within your organisation. If you undertake an annual review of your privacy compliance, then you can identify shortcomings or areas for improvement, and as part of this there may be actions that you need to take, and these will need to be reflected in your internal documents, and any changes to internal documents obviously need to be properly communicated to staff. As part of any annual review, you should also think about staff training. Now, it may be that there are specific areas that you identify where training is necessary. For example, if you've acquired a new piece of technology to help with your compliance, then obviously you're going to have to train your staff to make sure that they fully understand how to use it. But you might also want to consider whether it's appropriate to have a general refresher. New staff will hopefully have received data protection training as part of their induction, but what about longer serving staff? 4 years is a long time, and it's probably sensible from time to time to think about giving them a reminder, particularly if you think that bad habits may have crept back in, or if you think there may have been a failure sometimes to correct behaviours. Maybe things have, a blind eye has been turned from time to time. One area where standards can have slipped among staff is in relation to data minimisation. For example, staff might have started storing personal data on desktops, or sending work emails from personal email accounts, or they might be keeping their own sort of lists of prospective clients and customers rather than using centralised lists. So there's quite a lot of different things to think about there, but hopefully a few things that you might be able to take away.
So number 6 on our list is providing privacy information. So under the GDPR, you are required to provide information to your data subjects about the data you hold about them and why you hold it. The individuals actually have a right to be informed about the collection of use of their personal data, and the information provided must be concise, transparent, intelligible, easily accessible, and in clear and plain language. So, as we've already touched on number 3, once you know where you hold the data, you need to explain this to data subjects. One of the easiest ways to do this is through a website privacy policy, your websites, so that they're accessible to the general public. and find these on company website. But in doing so, you need to make sure that this privacy policy is wide-ranging as possible. So it needs to cover all the types of personal data that you hold and why you process it and the reasons that you do so. More detailed information can then be provided to specific categories of data subject, perhaps via a separate privacy policy, which I'll go on to in a minute. The specific information that you need to include in your privacy policy is set out in Article 13 of the GDPR. And this will include the contact details of the controller. That's the person who determines the purpose for the data processing. And if you have a data protection officer, the information and contact details for them, the purpose of the processing, the recipients of that personal data, so where you share that personal data with other processors or sub-processors, if you transfer data outside of the UK and what safeguards you have in place if you do so, and the data subject's rights, which I'll touch on later. So this would be best placed on your website, and it will cover the event that a customer or data subject comes to you and says, I want to know why you process personal data. You can hand them your privacy notice or your privacy policy. Separately, it might be a good idea to have individualized privacy notices for specific categories of data subject. This is something that then can be internal and doesn't need to be available publicly. An obvious example of this would be something like an employee privacy policy, setting out the data that you hold of your employees. Or you might want to have one for a specific piece of software or app that you have, or specific customers that you process personal data for. So it might be worth you considering whether one privacy policy fits all, or whether it would be good to have some separate specific ones for certain types of data processing that you are doing. Again, it's really important to make sure your privacy policies are regularly reviewed and updated. If you haven't looked at them for the last few years, perhaps consider whether they need to be checked to ensure that they reflect and are up to date. It's also pretty obvious to see where people haven't updated their privacy policy to reflect any change in the law. And this is something that I often see and often pick up on, but it's an obvious one to make sure that you are reviewing your privacy policies, perhaps again as part of an annual review, to make sure that it's not got any inaccurate or missing information and that it reflects the latest laws. Moving on to data security, just another thing to consider really that we think is quite important. So ensuring you keep data secure and reducing the risk of data breaches. Now this can kind of encompass two main things here, one being sort of reducing human error and the other being more technical IT type security that you can have in force. And of course it's important to say that this will be different for each organisation, and because you will all process different types of personal data and the sensitivity as such might vary. So you should be thinking about ensuring that your personal data is processed in a manner that ensures appropriate security. So think about your IT systems, think about whether you allow your employees to bring their own devices to work, and think about whether there's any other ways you can ensure you avoid unlawful processing and accidental loss or damage. So think about whether your IT security is up to date. Do you actually know where your data is held? And what are the policies around data deletion and perhaps encryption and other types of security types, which I'll move on to in a minute. Also consider organizational policies. Do you have a retention policy where you know how your data, when your data is deleted, or where it's backed up? Do you have a security breach response plan? Do you keep incident logs in the event of a data breach? And do you have a record of processing activities? If you don't, it's probably worth considering undertaking analysis of this and thinking about the risk presented by the data you process and where there might be gaps that need filling in. Also think about the more technical measures such as encryption and pseudonymization. Are you able to restore access and availability to data in the event of a data breach or data loss? And where would this be kept? It's making sure that you sort of have everything in place to prevent, the worst, if there is a worst case scenario, that you're prepared and you're able to ensure that it's not as bad as it possibly could be. And more low tech, thinking about your physical security. Do you have a filing cabinet that's unlocked, that's got loads of personal data in it that hasn't been touched for a while? Should you think about physical security in your office? Is it worth installing CCTV? And what's your processing on disposing of paper and electronic waste? How do you do that? How do you ensure that that's secure? As important that this is appropriate to the size and use of your touched on before, it's important to work in information systems and the data that you hold. Not one size will fit all, but perhaps something to reconsider if you haven't thought about it for a while. One more poll, just to kind of emphasize this point. So I'm just going to bring it up. What precautions should you take if you're using your own device for work? Install the latest security updates, follow your company's bring your own device and password policies, keep the device safe and don't let others use it, or all of the above. Okay, I think most of you have voted now. Yeah, most of you were right. The answer is all of the above. Just emphasizing that there might be quite a lot to consider if this is something you do, and just knowing where your gaps are in your data security and where there might be possible sort of vulnerabilities that might expose you to a data breach in future.
Okay, thank you, Charlotte. So moving on to number 8 in our top 10, taking care before sharing personal data. It's quite possible that as part of your GDPR preparation, you undertook a data mapping exercise to understand how data flows into and out of your organisation. But this sort of thing rarely stands still. Things may well have moved on since 2018. It's likely that you'll have entered into new contracts with suppliers and customers in the last 4 years. As Charlotte mentioned, your privacy policy should always explain who you share personal data with, why you share it, and where it's stored. And a periodic review of your data sharing arrangements should help you to recognise any changes, make sure that they've been appropriately approved internally, and where necessary, update your privacy information. A couple of examples might illustrate the issues which arise when data sharing arrangements change. So, for example, in the last 4 years, you might have outsourced a function which you previously handled in-house, say your HR function, and so now your supplier processes personal data relating to your staff for you rather than you do that in-house. Your contract with the supplier will obviously need to include appropriate data processing terms, and you'll need to check whether the privacy information that you provide to your staff in employee privacy notices covers this scenario, covers the possibility of the employee's personal data being processed by an external HR services supplier. If it doesn't, then you're going to need to update your privacy notices. Where you have a change that is something that might be covered in your external privacy policy on your website, then hopefully that policy will have been drafted in sufficiently flexible terms that it doesn't need updating every time you appoint a new supplier, for example. But having an annual review should pick up anything that might have slipped through the net. The example I mentioned was a relatively straightforward one. Another situation might be less so. Let's say, for example, that you decided to purchase some new technology. You probably would undertake a data protection impact assessment, which I'll talk about later, before implementing the new technology. And that assessment might have identified that personal data is going to be exported out of the UK. Your supplier's terms may already include safeguards, for example, the EU standard contractual clauses or the UK's new international data transfer agreement to enable the transfer to be made. but there would still be work for you to do. For example, you'd need to conduct an adequacy assessment before any data was exported, and you'd need to update your privacy policy to make sure that this particular data exporting was included. So in that scenario, there could actually be quite a lot of action needed in order to keep abreast of the rules relating to the sharing and exporting of personal data. Thanks, Charlotte.
So 9 on our list is respecting data subjects' rights. Now, I've set out on the slides all of these. It's often important to include these in your privacy policies, as I set out before. I want to focus in particular, though, on handling complaints and specifically subject access requests, as I'm sure these are something that you may have come across or that you are fearing that you might have to deal with at some point or another. They can be quite administratively heavy, quite a burden on your resources if they do come in. Essentially, a data subject has a right to request copies of the personal information that you process about them. You used to be able to charge for this, but now there's very limited circumstances in which you can charge a fee for doing this. You must respond within 1 calendar month, and it can be quite labor intensive, searching through all the personal data that you hold about somebody, and you may also need to redact any other personal information that you hold about someone else that's included within that data. But sort of starting at the beginning, really, it's really important that you recognize what a data subject access request is, so you can ensure that it's handled in the correct way. So I've just got a quick poll. So a data subject access request must always be made in writing. Is that true or false? See if we've got a few more. Interesting. It looks like we're split down the middle on this one. The correct answer is actually false. There is nothing in the legislation to state that a data subject access request must be made in writing, which of course makes it more difficult for recognizing it because you could make one verbally. We would always advise that if you receive a verbal request for a data subject access request, that you ask the subject in question to follow this up in writing, so you have a trail of it and ensure that it can all be recorded in the correct way. But it is important in that sense to make sure that you recognise that a data subject access request does not have to be in a certain form or sort of certain format. Some companies do like their data subjects to fill in a certain template form, but again, I must emphasise that it doesn't have to be in a certain format. So you must ensure your staff are trained to recognise where a subject access request has been made and ensure that you know who to speak to and who to talk to about ensuring that you comply with the requirements to do so within 1 calendar month. And then specifically, I wanted to just talk about dealing with complaints, because again, I think this is something that you might experience or you're fearing that you might have to experience, and making sure that you're ready to handle any complaints. Your privacy policy should explain that where complaints can be made. You might have a specific email address for addressing complaints, and you must also ensure that the data subject is aware that they can make a complaint to the ICO, but we'd like to think that this is really the last resort and that you'd be able to handle any complaint in-house first before a data subject feels the need to go to the ICO. You should ensure, if they're not already, that your staff are trained to recognise complaints, and if they receive one, if they have a person that they can pass that complaint on to. If you do receive a complaint, you should ensure that you investigate it fully, retain any relevant data, and comply with any deadlines, as I've touched on before. The ICO does have a high expectation, and whilst a data subject can make a complaint to the ICO like to think that this is very much the individual's last resort, and if they receive a complaint, they may refer it back to you to ensure that you make further efforts to resolve the complaint. This being said, a data subject does have the right to make these complaints, and worst case scenario, you'd be looking at a fine, potentially at least. Therefore, it's important to make sure that you do handle these complaints, that you take them seriously, and that you have the policies and processes in place to ensure that in most cases, hopefully, if not all, that you resolve the complaints as best as possible.
Thanks, Charlotte. And that comes on to our final item in our top 10, thinking about privacy before implementing innovations. If you're planning a new process or project, you do need to think about undertaking a data protection impact assessment, or DPIA. This is a process to identify and minimize the risks of associated with the change from a data protection perspective. DPIAs are mandatory in some circumstances, namely if the processing or the new processing is likely to result in a high risk to individuals. There is a checklist on the ICO website to help you work out whether an innovation falls within the mandatory category. But even if it isn't mandatory, I'd say it's still good practice to carry out a DPIA before embarking on a major project. The DPIA should involve your data protection officer or other lead sort of person responsible for data protection matters, and any other relevant stakeholders in the organisation. You might also need to consult with third parties. For example, if you're going to be buying new software, you might need to consult with the supplier about how their product will impact your privacy compliance. You'll probably need to ask questions about where the data that will be held in their software, where the servers holding that data will be located, and if it's going to be transferred out of the UK, what precautions they have taken to make sure that that data is adequately protected. The DPIA needs to cover off a number of different things that you need to think about as part of assessment of the innovation. So you need to think about the nature, scope, context and purpose of the data processing involved in the innovation. You're going to have to assess whether the processing is really necessary, whether it's proportionate to the benefits of the innovation, and whether it will comply with the rules. So, for example, if the innovation is going to involve the exporting of personal data, as I touched on earlier, you're going to need to think about how you comply with data exporting rules. You also need to assess the risks to individuals from the processing, the likelihood of harm to their right of privacy and the severity of that harm, and think about the measures to mitigate any risks that you have identified. If you identify a high risk and you cannot mitigate it, then you need to consult the ICO before you start the processing. And if the ICO doesn't give its go-ahead, then you mustn't proceed. Your internal policies and procedures, as I touched on earlier, need to cover off the requirements for DPIAs, and your staff should be trained so that they understand when one is necessary and what they need to do. Then when any innovation is planned, it's good practice to start thinking about the DPIA aspect at an early stage, rather than thinking about it or remembering about it at the 11th hour, and that possibly holding up the implementation of whatever change you have planned. Now, for many organisations, DPIAs were not necessarily something that were very important when getting ready for GDPR in 2018, but you can see that they're very much part of how your processing activities may evolve over time, and they're an obvious example of why compliance is an ever-evolving topic, and why you need to try to keep abreast of the changes in your organisation and how they impact upon your privacy compliance. So that concludes our top 10. Before we move on to your questions, we've got one final poll for you. If you could bring that up, please, Charlotte. So based on our top 10, how many takeaways have you identified? Less than 3, our organisation is in good shape. 4 to 6, there's room for some improvement. 7 to 10, we need to do a lot more. So I'll just give you a minute or two to respond to that. Have we got the results there, Charlotte?
Let's pull them up.
Okay. So I'm pleased to see there's a lot of you feeling in quite a comfortable position, and that there aren't too many who feel that they've got a lot to do. But you know, for many of us, there are areas where we could do more. So I hope what we've sort of suggested gives you some food for thought. We'll now turn to your questions. Charlotte, do you want to sort of pick up on the things that have been brought up?
Yeah, haven't had too many in. If anyone does have a question, please do leave it in the question box, and we'll see if we can answer it now, or we will respond to you separately after the webinar. Had a few come in so far. So one around data breach. So when do we have to tell the ICO about a data breach?
Well, there's 2 bits to data reporting. The first is the internal reporting piece. As I touched on earlier, it's really important that all data breaches, however small, that might just be sending an email to the wrong person, they should all be logged internally. So there's I would say that your internal rules should require all staff to report those internally. The person responsible for data protection, whether that's a formal DPO or other person, will then make an assessment as to whether the breach should be reported to the ICO. There's a useful tool on the ICO website, a really simplistic thing, but it's quite a handy thing if you've not looked at it before, to help you make that preliminary assessment as to whether to report or not. You can also phone the ICO and ask for their guidance or seek professional advice. Probably for many organisations, it will be best to err on the cautious side and submit a report. But obviously, you do need to sort of take a balanced approach, because you don't want to be in a position where you're filing reports with the ICO too often, because you know that's not going to create a good impression with them.
Okay, and I think we've just got time for one more. So there's just looking at, I know I talked about consent, and I mentioned it very briefly, but looking for some clarity around what implied consent is, and how that's different from not implied consent.
Yeah, well, I think you sort of touched upon how the rules around consent have really changed as a result of GDPR, and the bar has really increased. So relying on implied consent really is something from the past. You've got to have explicit consent. It needs to be informed, so there needs to be information provided, not just in your privacy policy, but also at the point when consent is collected, just a short statement, possibly with a link to your full privacy policy. It needs to be specific, so you need the when consent is being given, the individual understands that it's been given for a very specific reason rather than just a general consent. So where, for example, you're relying on consent for marketing purposes, it's good practice to offer sort of granular options so people can opt in and out of different things rather than just having a general consent. So the idea that you can rely on some sort of implied consent, that it must be the case that someone has consented, really is something that you need to keep well away from now. Consent can be a useful basis for processing personal data because it means that you've got that sort of confidence that the person does want you to process their data. But because it needs to be capable of being withdrawn just as easily as it's given in the first place, it does need to be for things which, from your perspective, are relatively sort of optional. So, for example, marketing is a classic example. You can rely on consent for marketing because if somebody says, well, no, I don't want you to use my personal data anymore, there's not likely to be any sort of difficulty from your perspective in removing them from your lists.
Thanks, Catherine. I think given the probably best to wrap this up now, but we will time we'll respond to any other questions on email after the webinar. It's not a problem at all.
Yes, that's right. I'm sorry we rather sort of overrun. You'll appreciate it's a big subject and this has been very much a whistle-stop tour. We haven't covered everything by any means, but I hope you've all found some useful ideas to take back to your organisations. If there are any other specific questions that you've got, please do email Charlotte or me if you'd just like to have a chat about where to go from here. Otherwise, that just leaves me to thank you again for joining us today. Please do complete the survey and take part in our draw for the John Lewis vouchers. I hope you'll join us again for another FSP webinar, but thanks again and have a good rest of the day. Thank you.